हाय हेलो वेलकम एवरीवन। आई एम श्योर आप अपनी पढ़ाई के अच्छे से कर रहे होगे। आज जो चैप्टर लेने वाला हूँ वो है सीआरपीसी, अनदर वेरी इंपॉर्टेंट चैप्टर्स दिसंबर 22 अटेम्प्ट के लिए। तो सीआरपीसी में इंपॉर्टेंट टॉपिक्स क्या क्या करके जाने, एंड रिमेंबर मैं बार बार इंसिस्ट कर रहा हूँ इंपॉर्टेंट टॉपिक्स के ऊपर। मैं ये नहीं बोल रहा हूँ कि यही क्वेश्चन करके जाओ, ये टॉपिक्स के बारे में अच्छे से जानकारी रखो, ठीक है। तो एक इम्पॉर्टेंट टॉपिक जो सीआरपीसी में आपको पता होना चाहिए वो ये है, मेंस्ट्रिया इज जनरली नेसेसरी फॉर लाइबिलिटी इन क्रिमिनल लॉ। यस, मेंस्ट्रिया के एलिमेंट्स क्या है, उसके फंडामेंटल प्रिंसिपल्स क्या है, व्हाट कॉन्स्टिट्यूट्स अ मेंस्ट्रिया, प्लस उसके साथ गिल्टी इंटेंशन क्या होता है, कब क्या चीज पनिशेबल है, प्लस एक जनरल रूल क्या है मेंस्ट्रिया का कि देयर मस्ट बी अ फॉल्टी माइंड, गिल्टी माइंड। मेंस्ट्रिया इज सब्जेक्टिव एंड मेंस्ट्रिया इज वेरी एसेंशियल इंग्रेडिएंट, ठीक है। देन ये वाला क्वेश्चन भी देख के जाए ना, डिस्टिंग्विश बिटवीन अ बेलेबल एंड अ नॉन बेलेबल ऑफेंस। बेलेबल ऑफेंस की जहां तक बात करूं तो एज पर द फर्स्ट शेड्यूल जो भी ऑफेंस बेलेबल है वो, और नॉन बेलेबल की बात करूं तो जो भी ऑफेंस अदर देन बेलेबल है वो नॉन बेलेबल है। तो जरूर पढ़ के जाना। देन यस दिस वन, कॉग्निजेबल ऑफेंस एंड नॉन कॉग्निजेबल ऑफेंस। कॉग्निजेबल ऑफेंस का मतलब वही होता है जहां पे पुलिस कैन अरेस्ट अ पर्सन विदाउट अ वारंट एज पर द ऑफेंस स्टेटेड इन द फर्स्ट शेड्यूल या एज पर लॉ। और नॉन कॉग्निजेबल का मतलब होता है जहां पे पुलिस ऑफिसर हैज नो अथॉरिटी टू अरेस्ट विदाउट अ वारंट। ये है फर्क कॉग्निजेबल और नॉन कॉग्निजेबल। जनरली ऑफेंसेस कॉग्निजेबल के नेचर के रहते हैं अनलेस दे आर स्टेटेड टू बी अ नॉन कॉग्निजेबल, ठीक है। देन यस दिस वन, डिफाइन कंप्लेंट अंडर द सीआरपीसी या फर्स्ट इंफॉर्मेशन रिपोर्ट। जनरली कंप्लेंट क्या रहती है, जब आप कोई एलिगेशन पुट अप करते हो इधर ओरली और इन राइटिंग बिफोर द मैजिस्ट्रेट विद द इंटेंशन ऑफ टेकिंग सम एक्शन अगेंस्ट द पर्सन, तो आप एक कंप्लेंट फाइल करने की बात करो। इट कैन बी इन द नेचर ऑफ अ पिटिशन ऑल्सो बिफोर द मैजिस्ट्रेट वेर यू पुट द एलिगेशन ऑफ एन ऑफेंस कि इस तरीके से सो एंड सो चीजें थिंग्स हैज हैपेंड, दैट्स अ कंप्लेंट। एंड आपको इसके साथ साथ जो सपोर्टिव एविडेंसेस फाइल करने हैं फाइल कर सकते हो। उसी तरह अगर पुलिस ऑफिसर अपनी रिपोर्ट देता है तो वो भी एक तरह की कंप्लेंट हो जाती है, क्लियर। देन कंप्लेंट का ये नेचर है, प्लस ये भी ध्यान रखना कि एक कंप्लेंट में कंप्लेंट ओरल भी हो सकती है। सम पर्सन जो नोन अननोन है उस ऑफेंस का वो भी बता सकता है। इट कैन बी मेड टू द मैजिस्ट्रेट कंसर्न और इट कैन बी टेकन टू एनी अदर पर्सन। फर्स्ट इन्फॉर्मेशन रिपोर्ट क्या है? फर्स्ट इन्फॉर्मेशन रिपोर्ट होती है जहां पे कोई ऑफेंस, कमीशन ऑफ कॉग्निजेबल ऑफेंस हुआ है एंड आपने वो चीज ऑब्जर्व की है, यू हैव बीन अ विटनेस टू इट। तो आप ओरली ऑफिसर के सामने अपनी कंप्लेंट, अपनी फैक्ट्स पुट अप कर सकते हो। दैट्स कॉल्ड रिड्यूसिंग द कंप्लेंट इन राइटिंग बिफोर द पुलिस ऑफिसर। उसको बोलते हैं फर्स्ट इन्फॉर्मेशन रिपोर्ट। And every such information has to be signed by the person who is giving it, and the substance has to be recorded in that book in the precise manner, in the words of the person who has given it. And the first information report FIR की noting police officer बराबर से करता है, and the investigation shall proceed only after an FIR has been noted. Any person who has been aggrieved by the refusal of that person, and any person aggrieved by the refusal on the part of the officer कि मेरी FIR report नहीं कर रहे, so you can make a written complaint to the superintendent of police, या आप उसको directly approach भी कर सकते हो। And if the SP or the commissioner of police जो भी आपके जोन में लगता है वो satisfied है कि ये offense cognizable का है, तो he will ask a complaint has that is FIR has to be noted. Okay, and yes, you can always demand a copy of the information that has been provided, ताकि बाद में कोई confusion ना रहे कि नोटिंग्स क्या गई थी या फिर हम लोग ने क्या क्या कंप्लेंट फाइल की थी। अनदर वन दो यहाँ पे ध्यान रखना, वो ये वाला क्वेश्चन है, या व्हाट इज इन्वेस्टिगेशन, इंक्वायरी एंड ट्रायल। ये सब में फर्क क्या रहता है? एक इन्वेस्टिगेशन क्या रहती है? इन्वेस्टिगेशन का मतलब होता है जहां पे यू कलेक्ट द एविडेंस बाय द पुलिस ऑफिसर और एनी ऑफ द पुलिस पर्सन। एंड व्हेन वी टॉक अबाउट इंक्वायरी, investigation, when we talk about inquiry means every inquiry other than the trial, that is, it is conducted as an inquiry, it is a part of the trial, it has a implication wider than the trial. They try to know that this thing has happened or not. What is a trial? Trial means any kind of proceedings, any kind of proceedings in the court of session. So when the process is examining witness, taking person on oath, that is called a trial. And what is investigation? Investigation, inquiry, trial, three terms होते हैं. So first stage is when the police officer Okay, first stage is when the police officer, either on its own motion or on investigation complaint, try to find out if any offense has been committed or not. Second stage is magistrate inquires into the case and find out, and if no offense is committed, no case is registered, then the magistrate may release the accused, or if the case something has happened, then the magistrate may frame the charges in that case. Okay, and the final stage is reached when the magistrate may try to see what is the case that has happened. He will commit the person to trial, and then that person can be charges can be framed against that person. Okay, clear? Now the other set of question that you must be looking at, yeah, this one. So what are the various powers of the courts? कोर्ट्स के क्या पावर्स हैं? एक फर्स्ट क्लास मैजिस्ट्रेट के क्या पावर्स है, एक हाई कोर्ट के क्या पावर्स है? प्लीज रीड करके जाना. हाई कोर्ट कोई भी सेंटेंस दे सकता है, सेशन कोर्ट भी कोई भी, जनरली डेथ सेंटेंस नहीं देता. असिस्टेंट सेशन जज जो है 10 years तक का इम्प्रिजनमेंट देता है. चीफ मेट्रोपॉलिटन या चीफ जुडिशियल मैजिस्ट्रेट जो है जनरली 7 years इम्प्रिजनमेंट, फाइन पे कोई लिमिट नहीं है तब तक. मैजिस्ट्रेट ऑफ फर्स्ट क्लास, वहां से फाइन का लिमिट आता है, तो 3 years इम्प्रिजनमेंट और 10,000. सेकेंड क्लास वहां से 1 year और 5,000. और चीफ मेट्रोपॉलिटन मैजिस्ट्रेट, उसके ऊपर भी फाइन का लिमिट नहीं है, तो ही कैन पास एनी काइंड ऑफ सेंटेंस. ओके, सो ये उनके पास होते हैं, प्लस सेंटेंस ऑफ इम्प्रिजनमेंट इन केस ऑफ डिफॉल्ट. तो अगर कोई पर्सन फाइन इम्पोज होने के बाद भी पेनल्टी नहीं देता, ओके, एंड इट प्रोवाइड्स द कोर्ट और मैजिस्ट्रेट में अवॉर्ड सच टर्म, तो वहां पे एडिशनल टर्म ऑफ इम्प्रिजनमेंट आ सकता है. दैट कैन बी नॉट एक्सीडिंग द पावर्स ऑफ द मैजिस्ट्रेट, and it should not exceed 1/4 of the term of imprisonment that has been given. Okay, so isko yaad rakhna. And yeah, do read this one also. A magistrate of first class passes a sentence of 3 years with a fine of 10,000 in case of failure and severe imprisonment. The convict feels aggrieved by the sentence. So in that case, अगर वो यहाँ पे section 29 यूज करेंगे, fine 3 years तक imprisonment और fine of 10,000. In that case, section 30 के हिसाब से CRPC, the court may award additional imprisonment if there is a default, and it can be going up to not exceeding 1/4 of the total term that has been imposed. In the present case, there is a 3 years का term. 3 years का term का मतलब 36 months होता है. 36 months का 1/4 is 9 months, but it should not exceed the total term. So total term यानी 3 साल से ऊपर, 36 months से ऊपर नहीं जाना चाहिए अगर punishment 3 साल के ऊपर है तो. Clear? तो ये जस्ट एक एग्जाम्पल था, बट इट वॉज अ गुड क्वेश्चन. डू रीड दैट. हाँ, डू रीड दिस वन ऑल्सो. Section 41 enumerates different categories of cases in which police officer may arrest a person without an order from the magistrate. So when can the police officer arrest a person without the order of magistrate? Section 41 कुछ ऐसे cases बताता है. तो जैसे who has been concerned in any kind of cognizable offense, who has any kind of possession of a housebreaking, who has been proclaimed as an offender, or in whose possession it is found that you can say it is found that some property is there which is suspected to have been involved in any kind of fraud, or who obstruct the police officer in conducting its duty, who is reasonably suspected to be a deserter from the armed forces, who has been concerned in any kind of infringing of the credible information, which creates a suspicion or a doubt that that person has done something wrong. And if that person is released convict, the one who has been released for some certain time in a payroll, and he is trying to elope that thing or jump it or breach it, so that person can be arrested, and for whose arrest and requisition has been made from another police officer. Okay, and yes, arrest to refusal to give the name. If any of the person is in the presence of the police officer, has committed some kind of crime which is a non-cognizable in nature, like a bailable offense, but they refuse to give the name or residence, then the police officer can detain the person for at least 24 hours, and they have to be produced before the magistrate within the 24 hours. Then arrest of a private person. Yes, that is, a private person can be arrested by a person in whose presence he has committed some crime. Okay, or he can be a proclaimed offender. तो आपकी आंखों के सामने कोई क्रिमिनल था और आपने देखा ये क्रिमिनल है, आप उसको अरेस्ट भी कर सकते हो. तो दैट इज इवन अरेस्ट बाय अ प्राइवेट पर्सन इज आल्सो अलाउड. क्लियर? इसके साथ साथ ये वाला पढ़ के जाइए. डिस्कस हाउ अरेस्ट इज मेड एज पर द प्रोविजन. सो सेक्शन 46 बोलता है, दिस सेक्शन ऑथराइजेज द पुलिस ऑफिसर और एनी ऑफ द पर्सन टू मेक अरेस्ट to actually touch or confine the person if required. This section does not give any right to cause a death of a person. Okay, and the police officer is authorized to pursue the offender in any place in India, and the persons arrested has to be taken before the magistrate within 24 hours, excluding the time taken for journey. Okay, and when a person is arrested without any warrant, he can be kept into the custody for 24 hours. Okay, and if it is produced before the magistrate can give a custody of nearly like 15 days, but not exceeding that, and the total custody period, unless the charges is framed, cannot exceed 60 days. And the person arrested shall be discharged only by executing a bail or a bond. And a person who is in lawful custody, he tries to escape, then the person in whose custody he is trying to escape can arrest him at any place in India. Okay, so that was the question that we have discussed. Okay, the other question that you must read for your exams, ये topic आपको पता होना चाहिए, that is called warrant of arrest. So what is a warrant of arrest? Every warrant of arrest is issued by a court under the code and shall be in writing. It has to be signed by the presiding officer. Such warrant shall be remaining in force unless it is cancelled by the court concerned. Then the form of warrant is Form 2. It must be in writing, must bear the name and designation of the person, must give a full name and description, and the offense must be charged with. It must be signed by the presiding officer. It must be sealed. Such warrant is only for the protection of person concerned and not for police officer. And the police officer or the person executing the warrant bearing the arrest without unnecessary delay, be provided such delay is not exceeding 24 hours exclusively. Okay, so that is the details about warrant of arrest. Then, yeah, write a short note on search warrant. Section 93 talks about search warrant. So search warrant can be executed where the court has reason to believe that the person to whom they have suffered has got some kind of documents or thing, or where the document or other thing is not known to the court to maybe in the possession of that person, and where the general inspection is necessary. Okay, but such warrant is not issued for searching any kind of document or parcel which is there in the custody of a postal and telegraph department or any kind of magistrate concern. And any magistrate or a district magistrate, subdivisional magistrate, any kind of magistrate, if they have the reason to believe that the person is confined under certain circumstances, and a search warrant can be issued that such person who is confined may be searched by the authority. So they can issue warrant of arrest in that also. Then, yeah, this one. What are the provisions in CRPC for peace and good behavior? So when the court of session or when the court of magistrate of first class, they find that something could be going wrong, some kind of offense could be committed, they can issue the order that to keep the peace and good behavior, a security may be executed by the person who will cause some kind of disturbance in the society, or that person can be taken into custody if required also, if that person is likely to cause disturbance in the society. Now, such peace and good behavior security cannot exceed 3 years. And if the conviction is set aside, then the bond becomes void and there is no money to be taken. Okay? And security for keeping peace and good behavior will where the executive magistrate, he receives some information that somebody will be breaching the peace, causing a disturbance in the public tranquility, will be causing breach of a peace or disturbing the public tranquility in any of the manner, then executive magistrate can ask that person to execute a bond that he will not be doing such a thing. So market ऐसे कई events हुए हैं where you felt like यहाँ पे peace and good behavior के लिए suitable you can say requirement must have been done, suitable steps should have been taken. Okay, yeah, this one, what is the provision for conditional order? Well, if the following public nuisance may proceed against. So if there is an unlawful obstruction or any kind of nuisance that should not be removed from the public place, you can pass an order for that. For carrying out any kind of trade or occupation which has been illegally stopped or maybe injurious to the health of them, then you can pass a removal of nuisance order or a stopping order. And the construction of any kind of building is going there, and debris are being thrown, and conflagrations have been caused, explorations have been caused, you can pass, that is magistrate can pass the orders, and the building, tent or structure is near a public place, so then orders can be passed. And dangerous animals out there, loosely hold, destroying the property, confine, or they can be confined, so then orders can be passed. Okay, that apart, the powers to issue order in urgent cases, well, where in the opinion of the district magistrate or any of the magistrate concerned that there is a sufficient ground and an immediate prevention is needed, in such cases the magistrate concerned can pass order to abstain any of the person or to do certain acts if it considers such direction is necessary for prevention or of any kind of obstruction, annoyance, or any kind of injury, any kind of disturbance that is caused. And under this section, an ex parte order can be passed in case of any kind of emergency or circumstances that do not admit such things has to be seen. Okay. Then, yeah. Discuss the power to issue orders in case of urgent nuisance 144. So same thing that you have just discussed. This is 144. So it was a June 21 ka question, 4 marks. So please read it well. Okay. And remember it also. Good topic. Then, yeah, do this one. What preventive measures can be taken by the police officer for 149? Well, a police officer is authorized to prevent the commission of any kind of cognizable offense. If the police officer receives any information of any design that the cognizable offense could be committed, then based on the information, he can take the action to stop this kind of offense. The police officer may arrest a person without any orders from the magistrate or without any warrant. The arrested person can be detained in the custody only for 24 hours. Any further detention requires a magistrate order. And the police officer is authorized to prevent injury to any kind of public property. Okay, so these are certain of the powers of the police officer or what preventive action can be taken by police officer. Okay, then, yeah, do this. Mr. Anand goes to police station, informs about the commission of non-cognizable offense. What should be the duties? Well, if he informs, information about a cognizable offense is different and non-cognizable is different. So if he informs about cognizable, every information relating to the commission of a cognizable offense has to be reduced in writing, and it has to be signed by the person giving, and the substance of information has to be entered in the prescribed book. And the copy of the information shall be given free of cost to the informant. And any person who is aggrieved by the refusal on the part of the officer can make a complaint to the superintendent of police. And if the SP is satisfied that the offense has been committed, he shall enter the same in the books or get an FIR registered. ये वाला पार्ट आपने FIR में देखा था. अब 155 देखते हैं जब NCs होती है, नॉन कॉग्निजेबल. So यहाँ पे information as to non-cognizable offense or non-cognizable cases and investigation thereto. So when the information is given to the police officer and it turns out to be a non-cognizable, no police officer shall investigate without the order of the magistrate concerned. And any police officer receiving such order has to exercise due care while taking the investigation into cases. And where the case relates to 2 or more offenses, at least one of the offenses shall be deemed to be cognizable. And the police officer has to investigate the cognizable cases as far as possible. In case of a cognizable offense, the police officer has to conduct a basic inquiry, and the police officer has to make the investigation and examine any person orally if it is required to. Okay, that was one of the good questions. Do read this topic and go. Okay, another topic that you should be reading, yeah, this one. When can magistrate take the cognizance of an offense? Section 190. Well, the court can take the cognizance of any of the offense only when the requisite conditions of proceeding against that person has been made, and the court has the jurisdiction to take the cognizance of the offense. Any magistrate, either of the first class or of the second class, upon receiving the complaint based on the facts that a police report or any kind of information that other than a police officer or based on his own knowledge, he can take the cognizance of the offense. Okay? Another topic, yeah, this one. Discuss in brief provisions relating to taking cognizance of the offense. So no court shall take the cognizance of the offense. This is a kind of limitation period. Remember, this is the kind of limitation period in CRPC. Generally, CRPC, you don't find limitation period, but this section prescribes a limitation. So if the offense is punishable with fine, then cognizance has to be taken in 6 months. If it is punishable with 1 year imprisonment, then 1 year, 3 years, then 3 years. And anything beyond 3 years, there is no limitation period for that. Okay. So the period of limitation relating to the offenses which may be tried together are determined on the reference of gravity of offense. Okay. Then section 469 comes into picture. Well, 469, it talks about the period of relation to an offender committing a offense. That on the date of the offense, if the commission of the offense was not known to the person who is aggrieved, then the first day on which the offensee comes to know, he can come and inform the police officer. And that's what happens in some of the serious cases, especially women-related cases. At times, women may not be aware of the offense, but when she comes to know, she can come and inform the police officer of the offense which has been committed. And where the identity of the offender is not known, the first day when the identity becomes known, then the person can come and inform them. And section 470 talks about exclusion of time taken. Well, while calculating the limitation period, certain time is not included. That is a period during which the another person is diligently prosecuted, or the period during which the continuance of the stay order or injunction is there, or the notice of prosecution has been given to the proper parties, or where the sanction or the consent for institution of any kind of prosecution is necessary, and the time is taken for obtaining that sanction or consent. And the period during which the offender is absent from India is not counted in limitation, and the period during which the offender is absconding or concealing is not counted. Now, what is the continuing offense? Well, in case of continuing offense, a fresh period of limitation begins to run every moment during which the offense continues. Okay, every moment during which the offense continues. That's called a continuing offense. Then, extension of the period, the court may take cognizance of the offense if there is a delay or necessary in the interest of justice to do so. Okay, and yeah. A commits an offense punishable with imprisonment which is extendable to 3 years. Soon thereafter, A went to America on 2018. A raised the objection that the court cannot take the offense. So this was a question, and as you can see in the given problem, A has committed the offense which is punishable with imprisonment 3 years. Okay, 3 years, and hence the cognizance can be taken up to 3 years. But while he is outside India, the period when he is outside India will be excluded. That is, central government will exclude that period. Hence, the magistrate can take the cognizance within the span of 2012 to 2018. This one, 2012 to 2018, will not be included in computation of that period of 3 years. So this was a good example and exam related question as well. Okay, so do read that. Okay, now another question, and an important one. Do read that for your exams also. So that question is this one. Which one? Yeah. Write a short note on record in summary trial. So what is a summary trial and what has to be recorded in the summary trial? So यहाँ पे summary trial means a speedy disposal of the case. It's a fast track disposal of the case and generally applied to two kind of offense which is punishable with 2 years thing. The criminal procedure sets out that any chief judicial magistrate, metropolitan magistrate, magistrate of first class, okay, they can try the offense in summary. If the offense is not punishable with death, imprisonment for life, or term exceeding 2 years, or it is not a theft, or any of the following, if it is just a theft and the value of the property stolen does not exceed 200 rupees, and if it is assisting or concealing a disposal of a stolen property where the value of property does not exceed 200 rupees, or the offense is under 454 or 456 of the IPC, okay, or it's a insult with intent to provoke a breach of peace, or it's any kind of abetment of foregoing offense or any kind of attempt to commit any kind of foregoing offense. That is, all the offenses that we have discussed above is a foregoing offense, or any kind of offense constituted in respect of a cattle trespass act. And what is the procedure for summary trial? Well, summary trial is a speedy trial. In all summary trial, the procedure is that irrespective of the nature of case, it's a summons case or a warrant case, the sentence of imprisonment cannot exceed 3 months. So it's like quick trial, and see what the magistrate takes care of. There is a serial number, the date of commission, the report of the complainant, the name of the complainant, name, parentage, and residence, the offense complained of, and the plea of the accused that his examination is taken, the findings, the sentence, and the date. So this is what the magistrate is noting in case of a summary trial. This is the prescribed form which has to be noted in case of summary trial. Okay. Then, yeah, this was a December 21 case. Discuss the power under 144. Again, 144 comes into picture. And issue the order in case of nuisance. So this is what we have discussed, the powers on 144. It was a December 21 case. And then, yes, explain the procedure in CRPC regarding the publication of proclamation of a absconding person, the one who has absconded from India. What are the publication of proclamations? Well, section 82 talks about proclamation. If any person is believed to have a warrant being issued against him, and that person is absconded or is concealing himself or hiding somewhere, and the warrant cannot be executed, and the court may publish a written proclamation requiring that person to appear within 30 days. Okay, and the magistrate concerned will record to his satisfaction that the accused has absconded, and it shall be publicly read with the conspicuous place in villages where that person is residing or does any kind of work over there, and it shall be affixed in the conspicuous place of the part of the house where such person ordinarily resides, or a copy thereof has to be affixed on some conspicuous part of the court also, and the court finds that a direct copy of proclamation be published in the daily newspapers also circulating at the place where the person ordinarily resides. So that was a December 21 question. And June 22 question, discuss in brief the powers of the court to try the offense under any other law for the time being enforced. So that is, it deals with one such power of the court to try the offense is divided in two categories, IPC or any other law. Section 26 of CRPC talks about this. 26 of CRPC says that any offense under the IBC may be tried by the High Court or Court of Session or any of the court as stated in the first schedule. Whereas any offense other than that, something like company law offense, SEBI related offense, or any other offense, that has to be stated in that particular law, like company cases or SEBI related cases, and if it is not mentioned, then it may be tried by the High Court or by the court concerned. So this section is very general section and is subject to certain provisions of CRPC. Okay, then what are the duties of a police officer making the arrest? 41B. So that's what we have read also. He has to bear in mind that who is he arresting, the accurate details, visible clear identification, prepare a memorandum of arrest. He has to lay down the name of the witness and inform the family member that who is arrested and get it countersigned by the person. He has to inform the person arrested under the memorandum that they have the right, or any of the relative or friend has a right to inform any of the legal practitioner. And in this case, okay, and yeah, the right of arrested person, 41D. 41D talks about when a person is arrested and that person is interrogated by the police, he shall be entitled to meet an advocate of his choice during the interrogation also. Okay. Explain the conditional order for removal of nuisance which is issued by the executive magistrate. Well, section 133 talks about that whenever a district magistrate or subdivisional magistrate or any other magistrate specially empowered, so we have to understand the conditional order for removal of nuisance. 133, we have already done that. So you have found out that where there is an unlawful obstruction, where somebody is carrying out a trade or occupation which is affecting the other party, where there is a construction of a building or any kind of substance, where there is a tent building is made, where any kind of tank or any kind of excavation is happening, or dangerous animals are left loose, then magistrate can pass an order for removal of such kind of offenses also. Okay, or such kind of nuisances also. And yes, companies can no longer claim immunity from criminal liability on the ground of incapable. So yes, company is liable. Well, with the time that we have today, a criminal liability can be fixed on companies also. A companies and association of persons and body corporates are very well can be made liable. In fact, companies are covered as a convict and not as a victim in each kind of cases also. So virtually companies no longer can claim any kind of immunity from the criminal prosecution. The doctrine of alter ego has come into picture. Vicarious liabilities can be fixed on the companies also. And there is a famous case, State of Maharashtra versus Syndicate Transport. It was clearly held where a corporate body is liable for any kind of criminal action which has been done by the body resulting from the act of the body, then a charge sheet can be filed on the directors, and even the criminal action of imposing fine or some certain relative positions can be fixed on the corporate body also, as per the relevant facts and circumstances of the act. Okay, so these are some of the important questions, and I'm sure you're preparing well. Do read this question, please do read this questions. These are some of the important questions that you must be doing, but I'm not asking you to ignore the other questions. I repeatedly say बाकी के भी क्वेश्चंस पढ़ के जाना, बट ये क्वेश्चंस पे अच्छे से ध्यान देना, विच आर रियली रियली इंपॉर्टेंट फॉर यू. ऑल द बेस्ट.